returnable. Manoj, may I only make one request? The resolution plan basis which my application was dismissed even to date has not been approved by the NCLT. Now, Manoj, may I only request for an interim stay until... We'll make it returnable in 2 weeks. Wait for stay as you can. Serve dusty and come. So good. Set of 5. April. See, in this case, the NABARD, though initially it said that, there may be certain irregularities in the functioning of the bank. Subsequently, it filed an affidavit before the High Court stating that the resolution of the board was proper and that there were no irregularities. Ultimately, this was a public interest litigation. You brought some grievance to the attention of the court. The court has felt that it is not necessary to interfere. Case 368 may be seen for a moment. What is that? Ordered by High Court, Honorable High Court. The earlier High Court, the earlier order. Yes, Lord. It says, Lord, pursuant to previous order, action taken, report on behalf of the NABARD has been placed on record. Prima facie, certain allegations were stated to be true. But that is prima facie. Subsequently, NABARD files an affidavit and says that you have now looked at it and there's nothing. Later, Lord. Anyway, as a PIL petitioner, your duty was to point it out to the High Court. High Court went into it. NABARD is a national bank for rural development. They file an affidavit. Now, why should we? But the error is 389 may be seen, Lord. Uttar Bihar Gramin Bank, as well as not the sponsored bank, Central Bank of India was directed to take decision on this erroneous activity. But that is my view. Ultimately, as a bank, it is regulated by the state authorities, since it's a state bank, as well as to a certain extent by the Reserve Bank of India. Why should we presume that they will not look into the any regulatory failures in the bank? Not any fraud above 3 crores is directed to be investigated by CBI. But here the quantum is not above more than 500 crores. That is, Sir Counsel, we are referring to the affidavit filed by NABARD dated 21st February 2024, where the averment is that it is humbly submitted that as per the specific directions dated 18 January 2024 of this court, the instances pointed out in the special audit report were scrutinized. On scrutiny, respondent number 4 is satisfied with the resolution of the board of UBGB that the guidelines of fraud are not applicable to the present matter, audit report, and therefore the matter is not required to be referred to local police/CBI as per clause 9.1 and 9.2 of respondent number 4. Initially, 13. I think you made our point clear. I think we'll not entertain it further. It is the PIL after all. Yes, dismissed it. Item 6. Okay. Item 6. Yes, Mr. Raghunath, you are on the screen. Advocate Raghunath on behalf of filed a writ petition before the High Court for early hearing of your appeal before the DRAT. And now you are in the Supreme Court under 136. We're not going to entertain these kind of... Your Honor, my Lord, these special is against the order of the Honorable High Court, and there is no sunmai, sir. There is no... about 24 hearings have happened. What do we do? The tribunals are... It's not that the tribunals don't have work. They have their own priority. But my Lord, it's a question of recovery of 208 crore rupees. I know, but you are postulating that your case is the most important to be reaching the line or the queue. Other cases may be as important before the tribunal. Why should we expedite your case? We will not do anything like that. Thank you. Dismissed.
This is a petition seeking appointment of an arbitrator. The clause of arbitration which finds place in the SPA was SHA, which was initially disputed by the other side, gradually accepted on an affidavit and recorded by the High Court in its order, saying that they were trying to mislead the court, but they then accepted the existence of the SHA and the arbitration clause. We are only seeking appointment of an arbitrator because one of the respondents is a Sri Lankan citizen and the other is an Indian citizen, both of them being shareholders in the company, which was created pursuant to the SHA.
Sir, I'm appearing for the respondents here.
Let them supply me a copy. I'll come back in 2 weeks and give my no objection for the appointment. For the appointment of the arbitrator? Yes. After perusing the agreement, because there was a confusion about the agreement per se, okay. Notice of invocation says the arbitrator. Fair enough. You're appearing for both the respondents, right? You're appearing for both the respondents. Yes. Fair enough.
Well, they've admitted the existence of the...
He doesn't have a copy of the papers. He's on caveat. So I'm not in caveat also. I'm just appearing. Issue notice. Mr. Can I have your name? Karthik Malhotra. Karthik Malhotra. And counsel appearing on behalf of the... states that he has instructions to appear on behalf of the respondents and seeks a short adjournment to take instructions. A copy of the paper book be supplied in the electronic form to the Senate Council for the respondents. List on... Should we keep it on Monday and finish it on Monday?
Please, my lords.
My lords, Friday is... all right, next Friday. Next Friday.
Very good. Next.
Yeah, man. Item number 8, my lords. The candidate who was selected as the president of the Consumer Disputes Redressal Commission for Mallarkotla.
Sangrur.
As for Sangrur. The candidate who was selected resigned.
Within 6 months.
Within 6 months. In which case, you are the second candidate. You have no vested right for appointment.
No,
if the candidate does not accept the appointment, then the second candidate can say that, well, appoint me to the post.
There's only
once a candidate is appointed, then the select list comes to an end because the process is
our submission was only this, Lord, that the OM says that if a person joins and resigns or vacates within 1 year, then, my lord, the merit list has to follow. In this case, my lord, the OM is there, and the judgment of my lordship, 3 judges of this court have said, and my lords, this is since a... No, that's right, Lord. But my contention is that since this is a judicial selection, instead of going through a fresh selection process, my lord, people can... And I'm there in the merit, my lord.
The government picked out all candidates who are lower in the list. That whole selection process in Punjab was replete with all kinds of difficulties.
What I have done is, in my district, Sangrur, after, my lord,
because the Punjab government thought that they can just pick up candidates who, are, suitable to them, overlooking the select list.
So that's my case. When one resigned, they appointed someone who was not even in the list, who didn't even apply. I was there at number 2. They didn't call me.
His appointment may be invalid, but he has no vested right.
So here he's R5, my lord. He's R5 here. I said so in my LPA. When the writ was pending before the Honorable Single Judge,
whom did they appoint?
They appointed one Jodh Karan, who was not even in the select list. Page 70 is the select list.
Look at it this way.
Yes, ma'am.
Your plea was appoint you. You're not really concerned about his appointment.
In the writ petition, it was appoint me. When the judgment is reserved in the writ petition, on that day, they appoint this person. I filed an LPA. I said, how can you appoint him? You have to appoint me. The OM is there in my favor. The 3 judges is in my favor.
Did you ever challenge his appointment?
In the LPA. Because in the writ petition, he was not appointed. He was appointed on the day when the judgment in the writ petition was reserved. So I could not have made him a party in the writ petition. I made him immediately in the LPA. I made him immediately in the LPA. I made an application, and he's R5 here before your lordships. A person who is not selected is working, my lord, as a presiding officer of the Consumer Forum, and I was there in the merit list. As a wait panel. OM says, my lord, the panel.
Petitioner, the grievance of the petitioner is that the candidate who was first in the select list, right?
Very well.
The candidate who was first in the select list for appointment to the post of president of the Consumer Disputes Redressal Commission, Sangrur, resigned. Full stop. Thereafter, full stop. The petitioner was second in the select list. Full stop. According to the Learned Counsel, after the judgment was reserved by the single judge,
yes,
and before it was delivered,
yes,
the 5th respondent was appointed as the president of the District Consumer Disputes Redressal Forum, though he was lower.
He was not in
though he was not in the merit list at all. Full stop. The petitioner has been non-suited on the ground that once the first candidate. Was it a fresh appointment then? They just picked him up without doing.
Picked him up without it.
All right, you've recorded your submission. The grievance of the petitioner, therefore, is that even if he was not eligible to be appointed as district, the grievance of the petitioner is that the selection of the fifth respondent is completely contrary to law, since since his name did not figure in the merit list at all. Full stop. Issue notice returnable on after 2 weeks. Thus the permitted in addition. Liberty to serve the standing counsel for the state of Punjab in addition. You have come here after 280 days delay.
Father passed away during this period. Father was very serious.
20 days.
20 days.
And on interest, claim is on interest in addition to the retirement compensation.
I invite your lordship's kind attention at page 19 only. Page 19, just it has been recognized. It has
What's
been
the point?
approved. Yes.
What's the point that you want to make?
It has been approved. It has been said that yes, this due is there.
You have to open the door. You have to first get the delay condoned.
My father passed away. I have said so. And he was bedridden, and
There's a delay of 280 days in filing the special petition, for which there's no satisfactory explanation. Stop. The petition is dismissed on the ground of limitation.
I circulated a note yesterday evening.
Yes.
My point is that it's a statutory violation and be under remedy
Tell
there.
us one thing. After the conciliation proceedings failed before the Facilitation Council, you have said that they never called upon you to file a statement of claim. Is
No
that
statement
correct?
of, I was a defendant, so no statement of claim is filed, no evidence, nothing. Just that the initial claim form which is filed before the MSME, which is an unrecent, just one page of form. On that basis, only the ultimate order is
Did you
passed.
get to file your statement of defense?
We did get to file once. We got to file once. But the conciliation, how it failed was that the first day I show up without the
Yes.
wakalatnama. That day itself, the other side prefers an application, already pre-drafted application. And on that basis of the application, same day, immediately the order is passed, there's no conciliation possible, let's move. But section 65 of the Arbitration Conciliation Act says, mandatorily both sides have to be called upon to file the written responses, and that concession has to happen in good faith. Even UK law and all, they have gone on to that level where they say that good faith
Assuming that conciliation failed, thereafter what happened before the...
no conciliation happened. Then I was called upon to file my defense. I filed. Then arguments reserved. Some fellow, one Mr. RK, heard the arguments. The ultimate award is passed by some other 3 people who have not even heard the matter. So RK is the signatures on
You've come here against which order?
But I've come with the order passed by the division bench of the High Court saying my 34 is not maintainable. 34 I should have gone on 34. Writ petition is not maintainable.
But you have a remedy under 34, right?
But I won't have a remedy under 34 because section 65 violations of the Arbitration Conciliation Act are not palatable under 34 grounds.
No, but what you are aggrieved by finally is the award.
Because I've tried to draw a distinction from that India Glycol judgment, which is falling for my lord. I'm conscious of that. There's a Jharkhand Urja judgment in my favor, which says if the mandatory statutory violations have taken place, then writ petition is maintainable vis-a-vis the MSME Act. Squarely covers my case. Number 2, my lords, the India Glycol judgment and the other judgments which my lords have held, those are cases people who are trying to make their cases on merits of the case. I am not on merits at all. I am on the violation of the MSME Act. And I am trying to portray my case there, my lords. So my humble submission is basic structure 226, etc. may be attracted when statutory violations have taken place. If it was a case on... In fact, it's
Problem is that you are yourself saying that you're not challenging it on merits, but only on statutory violations.
But the merits grounds are also there. I'm saying for the
The
statutory.
merits which you raised was that they were not registered as a micro MSME on the date of the agreement.
No.
So there's a finding of fact concurrently that they were registered.
No, what has happened is those merits arguments are also there. But to distinguish my case from the previous judgments, that's why I'm trying to portray my cases there.
Sold, supplied, and delivered. You have not paid them.
No, that's not the case at all. The case, my statement of defense is not on record. My apologies on that. But what if the transaction is slightly different?
Balance of the principal amount of 24.82 lakhs was not paid.
Because I'm like to deposit the principal amount. That's no difficulty at all. But the point is, my defense could not be brought on record because there's no procedure that has happened. There's no basic arbitration and conciliation norms that have been followed. In fact, because there's one Delhi High Court judgment which says if it shocks the conscience of the judge, then the petition is maintainable, even against MSME matters.
In a petition under Section 34, all these grounds, suppose in an arbitration, forget the MSME Act, arbitrator doesn't hear the defendant and passes an award. Is that not amenable to a 34 application?
I brought on Milos, the mandatory provisions of Arbitration Act not followed, ground under 34, absolutely correct, Milos. But Milos, this is under the conciliation process of Section 65 violations. So they may not be fall under the 34 Milos.
Conciliation.
And besides Milos, one person hearing the matter, other person passing the award, who I don't even know.
But why did you not choose to challenge the award under Section 34? All these grounds are available. That's your ground is there's a violation of public policy.
I'm only saying, Milos, that under the Jharkhand Urja matter, I'm squarely covered with those.
Thereafter, it becomes an executable decree, right?
Milos, may I say this, Milos?
For the rate is that you don't have to deposit.
Milos, may I say this, Milos? The Jharkhand Urja judgment which covers me is of 2021. My last judgment is of 2023.
Leave it open to pursue your remedies under Section 34.
I'm so grateful, Milos.
The petitioner had an efficacious remedy of challenging the award of the Facilitation Council under the MSME Act by taking recourse to the provisions of Section 34(2) of the Arbitration and Conciliation Act 1996. This was the matter, the High Court was justified in declining to entertain the writ petition under Article 226 of the Constitution. Hence, we are of the considered view that the grievances which are sought to be raised in these proceedings can be addressed in a petition under Section 34. Full stop. Any observations by the High Court on the merits in the impugned order shall not stand in the way of the petitioner taking recourse to the remedies to challenge the arbitral award.
I'll be hit by delay, Milos, because now.
But you can say you were bona fide pursuing your remedies before the High Court. What else can we say?
Milos,
I can't condone the delay which is beyond now the 90 days.
Milos, that's there, Milos, but that will be trying to be, Milos. It's a good case on merits, Milos. Milos have seen what has happened in this case, Milos. In fact, Milos.
Your vested right inures to their benefit. How can we obviate a limit set by Parliament?
Milos, I understand that.
Milos. Really speaking, if it's barred by limitation, you should just dismiss it. Otherwise, your client will spend another round of.
But my loss give me liberty, Milos may not fructify to my interest if the debt delay aspect is not covered.
All right. But we will not condone the delay here. You have to move.
Milos may only observe that I may permitted to raise this point. That will be Milos.
You can always say that condone it, but we can't because there's a maximum period which can be which is condoned. We can't go beyond that, like the IBC, the Arbitration Act. Condone the delay of 36 days in filing the SLP. There's no difficulty.
No,
then you can say I was pursuing my remedies bona fide before the Supreme Court.
I'm in my law's hands for us.
You can do it.
Item 11.
Sets aside, my lord, the well-reasoned decree and the judgment of the trial court. Para 15, my lord, it proceeds to record a wrong date, contrary to what has been pleaded by the plaintiff himself. And then, my lord, says that we were at fault in not pinpointing it promptly. My lord, three things were missing from the impugned judgment. If your lordship may please see, my lord, page 1.
You paid them 90% of the payment.
That's right, right.
So the dispute was only in regard to the balance 10%.
Lordship, please.
So the High Court says first, the very fact that you paid 90% shows that the work was being executed. Now, question still, you may still have a point that, there were delays or deficiencies on the part of the respondent. Where did you raise the issue of delays or deficits?
No, no. We have said so in the written statement, coupled with the fact, my lord, there is a finding of fact that the work completed was only to the extent of 90%. And therefore, my lord, the learned trial court held this. My lord, please have a look at page 175.
What evidence did you produce to establish that there were delays late?
Yes, yes. 30th of next year, P11, your lordships may see. Or my lord, lordships may please have an extra P12. Now, this letter, which we have pointed out, my lord, on 30th November 2012, the judgment in question says that
But tell us what is the evidence which you laid?
my lord, this was one of the letters, my lord, 30th November, and the rejection letters at document P11. Kindly just see, my lord, an extra P11 from pages 102.
You had to prove your defense that there were delays and that there were delays or deficiencies by adducing the evidence of a person cognizant of the contract which was being performed, and then establish, by producing documentary material that, there was a shortage of work or there was measurement carried out which resulted in,
If I may say so with respect, my lord, next year P11 pages 102 to 115 were the rejection notes. Then, my lord, the chairman of the company appeared as DW1, and then, my lord, 30th November 2012 letter, which was within the warranty period but not considered by the judgment in question, that has been set aside, my lord, on the premise that the work was completed in July 2011. But the plaintiff himself says that it was in 2012. Para 19, if I may just draw your lordship's kind attention, please have a look, my lord, at para 19, page 187. That is, my lord, the fundamental error, my lord, in the judgment. Besides the point, my lord, that para 19.
Ultimately, you are here under 136.
I know, my lord.
Not a problem.
My lord, only two respectful submissions. First and the foremost, my lord, the evidence, etc., my lord, even the bills which were presented. The learned trial court has held that these were not actually the bills which were submitted or ought to have been submitted. They have not been proved. Then, my lord, there is a heavy discrepancy on my pointing out the deficiencies, because the High Court says, my lord,
It's purely a matter of appreciation of evidence in our case. So thank you.
yes, right.
This has to be tagged. Ganpati deal.
This has to be done. Commerce, but it's kindly see the tribunal's order for a minute. It's PDS.
You are appearing for?
Well, I am on KV8. I don't know what the
We've got other matters which are pending, so we'll.
Well, the kindly see, because ultimately the tribunal, I had gone an appeal. The tribunal has decided this issue only on Ganpati Deelcom, not on merits. And with the liberty given that if review is allowed by the Supreme Court, please come back.
Therefore, we'll tag it.
Well, the question is because ultimately even my lords tag it.
We've got other matters pending.
No, I'm not saying no. It's not that they are remediless. Tribunal says if the review is allowed, please come back to us. That's liberty.
We'll keep it here.
On merits, ultimately,
We don't want to follow a different course of action because it will affect other matters which are pending. So we should notice and chat.
Sir, dismiss the numerous matters.
We'll keep it. We'll keep it here. Yes.
Well, ultimately, because my lord will be sending back to the tribunal notice.
All right.
Wait.
My lord, I'm only praying for a Passover, my lord.
Tell us what the matter is about. You argue.
My lord, the learned Solicitor General is leading us, my lord.
So for us, you are the Solicitor General at this moment. Tell us what the matter is about.
My lord.
The matter is about.
Argue for 5 minutes, then we'll look into.
Mr. Solicitor, just one second. Let a junior argue the matter. Please sit by his side. Yes. Tell us what the matter is about.
My lord, the matter is about non-filing of affidavit of admission denial along with the written statement, my lord.
So the High Court has relied on the Delhi High Court rules,
my lord,
according to which the list of documents has to be filed at a much anterior stage. It says without an affidavit of admission and denial, right? So the written statement, it says, will not be taken on the record without an affidavit of admission and denial.
my lord,
That's the Delhi High Court rule.
that's the Delhi High Court.
That's why you have been non-suited. Now, what is your answer to that?
My lord, CPC Order 11, Rule 4, my lord.
Yes.
It is very clear, my lords. The affidavit of admission denial has to be filed after interrogation and investigation of the documents have been done, my lords.
And what does the Commercial Courts Act say?
Commercial Court Act, my lords. This is the Order 11 Rule 4 as amended by the Commercial Court Act, my lords.
Right, but which is the provision of the Commercial Courts Act?
My lord, the Commercial Court Act amends CPC.
Which is the provision of the Commercial Courts Act which you are relying upon?
Page 15, my lords, of the impugned order.
Solicitor said 15, so you said 15. Hello, we should know this. All right. You've heard Mr. What's your name?
Avinash Agarwal.
You've heard Mr. Tushar Mehta and Solicitor General Mr. Avinash Agarwal. Issue notice. Tenable on. Till so and so further proceedings. Should we stay in the proceedings or further proceedings in the suit?
The real question would be, I could say,
The rules will favor over the Act, over the CPC.
There are 22.
Returnable on so and so. Pending till the next date of listing, there shall be a stay of further proceedings in the suit. Don't you know? Yeah, what happened was that they didn't fight. Uh, 123 days will focus on the
advocate when some eyes.
Item 14.
My lord, I beg to appear on behalf of the petitioner. My lord, firstly, my lord,
the issue is as to whether after the appointment of the arbitrator by the Calcutta High Court,
yes,
the Tripura Commercial Court could have refused to refer the matter to arbitration. And I think the High Court is
my simple answer to this, my lord,
the High Court had appointed an arbitrator.
without examining and considering the records that were lying before the arbitrator, which is completely a separate set of pleadings, my lord, before the arbitrator. My claim before the commercial court is completely independent of the dealership
All
agreement.
this can be argued before the arbitrator. Why should we entertain it as a
But the arbitrator, the Section 11 application on the basis of which the arbitrator has been appointed by the Calcutta High Court, my lord, is based on arbitration agreement.
The long and short of the story is that it can be sent to the arbitral tribunal. Why should we?
My set of pleadings in the commercials, it is completely independent of the dealership agreement. I am not at all governed by the dealership agreement. There is a basic misunderstanding on the part of the court, my lord. Secondly, my lord, without considering and examining the records lying before the arbitrator at Calcutta, my lord, the court could not have at paragraph 18, my lord. If your lordship kindly turns to page 15, paragraph 16.
Ultimately, what has the High Court done? The High Court has said, let the commercial remand order, saying that the commercial court should consider this.
Yes. And there could be parallel proceeding, but without looking into what was there before the arbitrator, the set of claims that were completely different. And my claim before the is a money suit, my lord. It's a simple money suit. It's a commercial claim. It is not a case of claim and a counter claim. My set of facts are completely independent of the dealership agreement. Paragraph 10 of the plaint, my lord, that is a different set of facts. Secondly, my lord, the High Court had interfered with order.
Who are you actually? Who are you in the sense? Who is your client?
Well, my client is the instant petitioner, my lord, who has filed the commercial court in the Tripura High Court, in the commercial division court in Tripura.
You are the dealer. Yes. You are the dealer.
No. Yes, I am a dealer. I am a dealer, but not eminently.
Maybe you are saying that your claim is independent of the dealership agreement.
Yes.
Your status arises as a dealer under the dealership agreement.
No, that dealership
agreement says, please consider our order to direct the commercial court to consider their order appointing an arbitrator.
Yes. Well, the arbitration agreement, which is between me and the dealer, maybe, my lord, it's an alleged document, is not at all a document which is with my custody. I have specifically stated in my plaint that I have never seen, this document has never seen the light of the day. In that event of the matter, my set of pleadings in the commercial court could have been in the light of the dealership agreement.
All this has to be looked at by the arbitrator.
The arbitrator deciding on the dealership agreement. That is for the respondent. That is the claim of the respondent against me. My claim against the Respondent is completely different, and my suit is a prior.
What's your point? No, it has to be before the arbitral tribunal. But anyway, we are not directing it has to be sent to the arbitral tribunal. The High Court has merely remanded the matter, directing the Tripura Commercial Court to consider its order, Calcutta High Court order appointing an arbitrator. That's all.
But my lord, this is where I join my issue, my lord. Just one minute.
Now I think we've made access clear.
To say, my lord, that the
Lordship, in item 15, it is in my humble submission that the Honorable High Court has committed grave error in saying that the minor dispute was transferred to respondent number 1 because it was transferred without following the provisions of law, and according to me,
But
it is
before
void.
that, you have to answer why we should condone the delay of 170 days in filing the SLP.
My Lordship, because the petitioner was not knowing that there is a limitation in filing the SLP in the Supreme Court, and the advocate who was dealing with the matter in High Court
On
was.
the ground of delay, yes. Thank you. Item 16.
My Lordship, may kindly consider as soon as we got the matter, we got it filed. My Lordship, may kindly consider because the petitioners are also very not very poor. My Lordship.
They have been in possession of the mine for the last 50 years.
But my Lordship, that transfer was illegal. My Lordship, that was
not case for injunction. The High Court says that somebody who was in possession of a mine for 50 years, they can't be now injuncted like this. So, if though we are discussing, we can say this. We can even say this. Though there's a delay of 170 days in filing the special petition, we've also examined the correctness of the impugned order on merits and find no reason to interfere with the order. The special petition is accordingly dismissed both on the ground of delay and on merits.
My Lordship, one last.
Better, so that item 16.
Not blacklisted. Issuing any show cause notice and contrary to the terms of the tender itself, if my Royal Lordship's attention to page 98.
The cancellation. Learned Senior Counsel appearing on behalf of the petitioner submits that the petitioner was blacklisted for a period of 3 years from participating in the contracts of the municipal corporation without a notice to show cause being issued. Issue notice confined to the above aspect. Returnable on.
Lord, we are only requesting for a stay, Lord, because I won't be in a position to participate in any of the options, my Lord.
We make a short note.
Lordship.
Oh, I see.
Lordship.
It's a due process.
Okay.
Number of petitions have been disposed of by the High Court. All the matters are not listed today. They pray for a one time.
But there's a 174 delay, 174 day delay here.
No. As far as the first matter is concerned, there is 74.
174 day delay.
In other matters, it is not there, madam. In other
174.
yes, but in other matters, the delay is not too much, madam. In some matters, it's
17. How many matters are there on 17?
In total, there are 7 matters, madam. All the matters are not listed today, madam. It will be taken after a week, madam.
You can get your other matters. We'll discuss this on the ground of delay. How can the state keep on saying that, look, the other matters where there is no delay, therefore condone?
I'm not saying, Kallis take up all the matters together because there's a delay part is concerned.
We will keep those other matters. We'll discuss this on limitation.
Kallis take up
limitation applies equally to everybody, and I think state governments in India now must be absolutely alert. And merely because it is a state, the government officers cannot just sit
as per my
allow
74, my lord.
And it's serial number 37. There is 74 days delay. We look at that matter independently. When it reaches, we'll take it up. This one we will dismiss on the ground of limitation.
My lord, I'm just telling that we'll take because on the technical ground, kindly see, my lord. Technical ground, my lord, they have to more than 3 or 4 crore rupees, my lord, kindly see. They have to pay more than 3 or 4 crore rupees, my lord, kindly see.
7 reaches. We'll see what the merits.
All the matters are not listed today, madam. If you've taken after a week, all the matters, madam.
How many are there?
In total, there are 8 matters, madam. Not 3 or.
Okay, give the number to the numbers.
Yes, I will put the numbers, madam.
List together with so and so
on Friday, madam. Next Friday. In the meantime, if there is defect, I will put the defect all day.
Item 18.
But it's on Friday, madam.
Next Friday.
Good.
This is a really piquant and unjust situation where I can't appoint an arbitrator. The matter is under litigation. Their appeal has been remanded by this honorable court to the High Court because it was earlier dismissed as non-maintainable. So the arbitration award has been set aside as being perverse at my instance.
And the arbitration award was set aside by the single judge.
Section 34 judge.
I think Justice Dhanuka's judgment.
That's right.
But we had dealt with this.
Justice Baldota's judgment.
Justice Baldota's judgment. There was a similar case which just came a few days back where there was the division bench set aside Justice Baldota's award on the
ground of perversity.
On the ground. What happened in the single judge?
So thereafter, after the award was set aside on the ground of perversity, they filed a Section 37 application, which was dismissed as non-maintainable. Then they came to this honorable court. This honorable court found the appeal was maintainable and therefore remanded it back
to the division bench.
To the division bench, and that matter is still pending. Though we have made requests, and this honorable court had also directed expedition, that matter is still pending. When therefore this matter is still pending litigation, and the situation is that a perverse award against me has been set aside, behind my back, 2018, they enter into a development agreement with respondent number 3. This is not disclosed. It is disclosed for the first time in 2023, where when I discover by chance that a huge construction is being put up, I move an application.
Mr. Ramchandran, what is the investment by your client?
The investment by my clients is 22 lakhs in a matter of 1.5 crore at that time. The amount should not matter at all. That was the initial payment.
If a construction has taken place and now you have invested about 22 lakhs,
he has paid 8 lakhs. The respondent number 3 has paid 8 lakhs. It can't go by the figures.
What seems to have also been impressed by the fact that now impeding the development, the tenants on the property who are waiting for being rehabilitated.
With respect, those tenants who are part of the original bungalow, it's not some resettlement scheme. It is a bungalow which is being demolished and a 15-story structure is being put up.
The award against you in the arbitration, right? The award in the arbitration. What is the actual award in the arbitration which was set aside?
The award was that I'm not entitled to specific performance and I'm not entitled to damages, both of which have been set aside because the award has been held to be perverse. So the matter is at large, and I file a fresh Section 11 application for the reason now that this third party has come. This third party seeks to get impleaded in that appeal. And I can't appoint a Section 11